for DRT. DRT upheld, stating that the bank has erred in classifying my account as NPA to deliver the possession within 15 days. The bank did not release my possession of the
You
three
came
properties.
before the division bench.
No,
Huh?
they went to bank went to DRAT,
All right.
agreed by the order.
All right.
So DRT also upheld the order passed by the DRT. It is erroneous, so kindly deliver the possession subject to 87 lakh rupees. Then I approached the division bench. Bank also approached the division bench. That then division bench order, kindly see the
Page,
order.
page 52.
Page 52.
51 and
52.
Yes.
Then the bank has filed 2 OAs. When my account is not classified as account as NPA, surpass at Barodil, then they have filed the OA. OA is housing loan separate madru. OA 12 up to the 19. Adu allow aitu. Against that, I have already prepared appeal before DRAT with regard to housing loan. But the club together, housing loan as well as the working capital, both the club madbuttu.
Now,
806 pending.
Now, 806 pending irli.
Yes.
Now, DRT said the action of the bank was wrong.
Yes.
DRAT confirms it.
Yes.
Division bench confirms it.
He 4.5 years early, bank was under the custody of the premises. Avaga government tax, AEB, maintenance. At that time, it was 2.5 crores. Now, bank is claiming 8 crores for no fault of mine. My Hero Honda showroom ittu. I lost it. My family distribute idayitu. Divorce overgu hogide. That is all separate. So I lost total business. So when loan account was 5.5 crores, I sold one of the property. 2.75 it was brought down.
Again claim ಮಾಡಿದ್ದಾರೆ ಇವರು.
ಇಲ್ಲಿ KB ಅವರು ಈಗ ಬಂದು ಲೈಟ್ ಬಿಲ್ ಕೊಡಬೇಕು, ಅರಿಯಸ್ ಎಲ್ಲ ಕಟ್ಟಬೇಕು, ಬಿಕಾಸ್ ಯು ಆರ್ ದಿ ಓನರ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಡ್ಯೂರಿಂಗ್ ದಿಸ್ ಪೀರಿಯಡ್.
ಬಿಲ್ ಅವರು ಓನರ್ಗೆ ಕೊಡೋದು
ಅಲ್ಲ, ಇವ್ರಿಗೆ ಬ್ಯಾಂಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಿಕಾಸ್ ಬ್ಯಾಂಕ್ ಹ್ಯಾಸ್ ಸೀನ್ ದಿ ಪ್ರಾಪರ್ಟಿ for 4.5 years.
Has been returned back in July 2023 itself, my lord.
After 4.5 years, 5 years.
That claim ಯಾವ period ಗೆ?
My lords,
KEB claim ಯಾವ period ಗೆ?
I don't know. I have not received this.
This one. ನೀವು ನನಗೆ ಕೋರ್ಟ್ಗೆ ಹಿಂಗ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
No, bank letter ನಮ್ದಲ್ಲ. KEB has addressed the bank.
When did you redeliver possession, madam?
Delivered possession on 27/7/2023.
27. When did you take possession, madam?
It was taken in
19.
19, my lord.
Date.
11/10.
11/10/2019.
Already preferred.
All charges, all statutory charges that are to be paid on the property will be paid by you between 11/10/2019 and 27/7/2023.
Claim has already been raised before the Debt Recovery Tribunal.
No problem.
Tribunal has gone through it,
No
and
issues.
the matter is posted for orders, my lords.
No issues. Yes.
My lord, and another thing, my lord, this period of 3 years, it was not in the possession, it was in the possession of the bank. However, the bank was
Symbolic
not
or physical, it was in the possession of the bank.
was in the possession of the
Yes.
bank, but bank was not permitted to realize it because of the conduct of the petitioner. He was filing
Can't
petitions
help.
after petitions.
Can't help. You were in possession of the property, physical or symbolic. Now he cannot be saddled with the dues.
But he should
Statutory dues.
sell the property. He didn't permitted us to sell the property.
Legal,
He was-
you lost all legal battle.
No, we didn't lose the legal
Then
battle.
what?
My lord, DRT only said that it is not classified as properly as NPA. Why? Because
That cuts at the root of the matter. When the account itself could not have been classified as NPA, all further proceedings are a nullity.
there was a misunderstanding of issues.
So division bench has confirmed that misunderstanding.
Division bench order, your lordships may kindly take out, my lord.
No problem. Yes.
My lord, kindly
I am
take
not
out
going to
division
hair
bench
split the division bench order except looking at the direction.
order. That it is not properly classified as NPA. It has only directed us to
1
hand over
minute.
the possession.
You lost the case before the DRT,
Yes, my lord.
correct? You lost the case before the DRAT.
No, my lords, we didn't lose. They have permitted, they have directed them to make half of the amount that was claimed by us. So we have in fact not lost before DRAT.
Why did you challenge it here?
We have challenged because we had to be paid the entire amount and not only 87 lakhs.
All right. That
Take
1
your
minute,
challenge.
1 minute. That was dismissed.
Yes, my lord, that was
That was
dismissed.
dismissed. That
And
claim
in
is
that
dismissed.
order- And in that order, division bench did not hold that we have classified it as
So
wrongly.
forget that. No problem. Division bench has dismissed your claim.
Yes, but that does not make us automatically liable for their actions,
Sorry,
my lords.
no. That I will pass the order. No problem. Yes. Now, ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
KEB ಅವರು 4.5 lakhs ಕಟ್ಟಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. They are already disconnected.
Who is in possession of the property now?
No, 27 July ಇಂದ ನಾನಿದ್ದೀನಿ 2023 ಇಂದ.
ಯಾವ ಪೀರಿಯಡ್ ಕೇಳಿದ್ದಾರೆ ಇದು?
ಅದು ಪೀರಿಯಡ್ ಅವರು
ಮತ್ತೆ ಪೀರಿಯಡ್ ಬೇಕಲ್ಲ.
that I will not only
As on March 23, so that is before delivery of possession.
so not only this statutory dues corporation water maintenance ಎಲ್ಲ ಅಧ್ವಾನ ಮಾಡಿ all wash and what it has been debited to my account, that has to be reversed.
Yes, yes, madam.
My lord, very simply, my lord.
Very simply.
Very
yes.
simply, my lord, because this account, my lord, it was classified as NPA in 2018, my lord,
Hmm.
because it was the loan that was revived, or rather, it was not a fresh loan. So the lower court had considered this loan which was reduced by limit as a fresh loan and stated that the NPA classification is wrong, my lord. On 15/6/2018, my lord, the facility that was available to them was around 5 crores, my lord.
Hmm.
That was reduced to 2.50 crores, my lords, because one property which was mortgaged to the bank was sold and the amount was
You
paid.
filed your
So,
objections, madam?
my lord?
You filed your objections here?
No, my lord, I have not yet.
When do you file it?
2 weeks.
Why 2 weeks? Till then, no dues will be claimed by any statutory authority on the petitioner. ಇದು ಬ್ಯಾಂಕ್ ಕಳಿಸಿರೋದಾ ಇದು?
ಬ್ಯಾಂಕಿಗೆ ಕಳಿಸಿದ್ದಾರೆ, ಅದು ನಮಗೆ ಬಂದಿಲ್ಲ
You
ಅಂತ
don't, you will not send anything to him saying that pay it till then. Yes.
now they are claiming 8 crores for no fault of mine. I lost my business.
That is an OA.
Today
my
on the
lord.
street.
My lord, under OA, they are liable to pay 10.94 crores, my lord.
Hmm.
Now, my lord, they have come forward here with the statutory dues, seeking statutory dues. But what happens to the liability to the bank? There is not even one murmur as to how they are going to pay. My lord, they have asked for permission to file counterclaim before DRT, my lord. They have not filed any counterclaim. There, the matter is pending for orders. And they have filed one more application basing on a cause of action on handing over the property, my lord. That application also is pending.
Now you file your objection.
I'll file my objections.
File your objection. Till then, no statutory dues that comes to you will be transmitted to him for payment.
Counterclaim has
my
already
lord.
been filed on 26 to
That's all
25.
right.
It is there.
Let the objections come about.
Please, my lord.
The petitioner is before this court seeking a direction to restrain the bank from taking any recovery measures against the petitioner for payment of statutory dues. It transpires that the petitioner initially secured finance from the hands of the respondent State Bank of India on between 3/1/2018 to 15/6/2018. The loan becomes sticky, allegedly becomes sticky, and the bank initiates proceedings invoking the provisions of the SURFACE Act 2002.
Lord, one small correction. The loan was taken in from 2012 onwards. The
That's all.
loan
Whatever.
became bad only.
Really, I'm not final order alive. Yes. So and so. The loan allegedly became sticky and the proceedings before the DRT was taken up by the present petitioner on the contention that the very act of the respondent bank in declaring the loan to be a non-performing asset was erroneous. The DRT appears to have allowed the claim of the petitioner, holding that the the declaration of NPA by the DRT was erroneous. Appeal is preferred by the bank before the DRAT. The DRAT affirms the finding of the DRT on with certain modifications. Both the petitioner and the bank are before this court, division bench of this court, in 2 writ petitions. The division bench of this court, by its order dated 13th July 2023, dismisses the claim of the bank, allows the claim of the borrower by the following reason. The division bench holds that the order of the DRT in declaring order of the bank, the action of the bank in declaring the account as non-performing asset was contrary to law, and passes the following order, page 51. It transpires that the bank redelivers the possession in terms of the order of the division bench on 27/7/2023. The bank took possession of the property on 11/10/2019 and redelivers the possession on 27/7/2023. Therefore, for close to 4 years, the property was in possession of the bank, symbolic or otherwise. The issue is, in the interregnum, there are several statutory payments that have emerged, be it electricity, be it tax or otherwise. possession was with the bank. The notice by the electricity companies are sent to the bank. Those notices are transmitted to the petitioner as if the petitioner had to pay all statutory dues at the time when bank was in possession of the property. This action of the bank is sans countenance. Therefore, the bank shall not, therefore, objections be filed by in the next 2 weeks, and the bank shall not transmit any bank shall not transmit any other notice issued to them for the period in which they were in possession, directing payment by the petitioner, pending further orders at the hands of this court. List the matter on,
Date may be given.
yes, sir. List the matter on 27th March. Object.
My lord, one thing I would like to point out, my lord, in this letter which he has now handed over, there is no period for which this claim has
Up
been
to
made.
March
Up to
2023.
March 23, but this is the reminder, my lord. But from what period that has to be.
Whatever it
clarified.
is. I said, I have told the period from the date of possession till the redelivery of possession.
But this notice pertains to which?
Forget that notice, madam. I have told all dues. Yes.
Not only statutory, watch and ward, interest, 8 crore they are
Well,
claiming.
we will pass appropriate orders. Yes.
Please,
Let
my
the
lord.
objections come about. Yes.
Please, my lord.
A for modification is there.
Under the petition, my lord.
Charitable endowments. ನಿಮ್ಗೂ ಅದಕ್ಕೂ ಏನು ಸಂಬಂಧ?
Sorry, sorry.
ಟೆಂಪಲ್ಗೂ ಪೇರ್ ಹಾಕ್ತಿದ್ದೀರಾ?
24.
ಎಸ್. ಅಥವಾ ಟೆಂಪಲ್ ಲೋನ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದಾರಾ? ಎಸ್. ಎಸ್ ರಾಜಶೇಖರ್.
My lord, the rest.
ಯಾವ ಕಾಪಿ?